Although it is not awarded in every divorce, spousal support is designed to provide financial support to the party with financial need. Historically, spousal support, previously called alimony, was awarded as part of a fault divorce to an innocent spouse. Because the husband had a duty to support the wife, alimony was seen as a way to compensate the wife for the change of circumstances outside of her control. As no-fault divorce became more commonplace, alimony shifted from a punitive response to one of financial self-sufficiency. Spousal support, as it is now known, can be awarded to either spouse upon a showing of financial need. Some states still consider fault as a factor. However, the overwhelming majority do not. The court considers factors relating to the financial situation of the parties during the marriage, as well as the situation of the parties after the divorce. In order to present a case for spousal support, the attorney must present information regarding the work history of the party, the salary history, work hours, and general responsibilities of the job. Information should also be collected during the interview that addresses the health of the client and future earning capacity he or she might expect. The educational training of the client should be considered, as well as the contribution each party made during the marriage. If spousal support is awarded, it can be made in one of three ways. Permanent spousal support is available to a party to assist during a specific time period. Contrary to its name, permanent spousal support does not last forever. If one party dies or the party receiving support remarries, spousal support is terminated. A lump sum payment of spousal support may also be awarded, although it may also be awarded in installments. Rehabilitative support may be awarded for a temporary time period to help the receiving spouse adjust to life separate from the marriage. For example, say Joan and David divorce after 20 years of marriage, and David has spent the last 15 years raising their children while Joan moved forward in her career as a dentist. David may be awarded rehabilitative support for a period of 5 years so that he can complete his college degree and begin a career of his own. In some states, spouses can receive compensation for the professional degree of their partner. In the example of Joan and David, David could be awarded a percentage of Joan's estimated future earnings as a dentist. Spousal support terminates in one of three ways. For rehabilitative support, a certain number of years or months is imposed at the time the support is ordered. For permanent support, the obligation ends with either the death of one of the spouses or the remarriage of the party receiving support. If a former spouse does not pay spousal support as ordered, a contempt action can be filed. If the former spouse is found to have willfully violated a court order, a court can order that payment be made within a certain amount of time, or the person will be jailed. Until 2005, individuals going through bankruptcy were unable to discharge spousal support in bankruptcy. The Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 changed that for certain bankruptcy filings. If the former spouse obligated to pay spousal support goes through a bankruptcy proceeding, the obligation may be discharged, terminating the support. As a general rule, spousal support is income to the receiving party and deductible to the payor. Property settlement agreements, on the other hand, are tax neutral. Parties may try to front-load spousal support payments by classifying settlements as support in order to receive the tax benefits. The tax code has implemented recapture provisions to avoid front-loading settlement payments as spousal support.